Well, hello and welcome to our BLSV14017 Town Planning and Control. First topic for the course, which is Introduction to Planning. Now, this Introduction to Planning will be an introduction to the course and also a bit of an overview of the planning process. So I hope you enjoy this fairly brief presentation. Firstly, what are the course aims? Well, the focus of the course is the examination of town planning and control, but specifically the effect of planning laws upon building surveying functions. So we're looking at it from the point of view of a building surveyor. As such, we're not going to explore the theoretical or philosophical underpinnings of planning theory in any great depth, but rather we're going to examine the planning process. So the reason for this is that building surveyors need to understand how planning controls operate and how to navigate through planning legislation and also how to research relevant case law. Unfortunately, planning law seems to be more about process than outcomes, at least in Queensland at this point in time, and so it's on this basis that the course will be taught. Now, we have a textbook for this course, which is Urban Planning and Real Estate Development, and this textbook is either available as a hard copy or it's available as an e-book. So if you go to the library, you'll be able to download it as an e-book, but we'll put a posting up on the website to show you how to access it. It's a very useful book. And within the textbook, one of the most challenging issues when engaging in town planning is that of remaining conversant with the vast amount of documentation cascading from national and local government. And it is my experience that that is a fair comment. There is a huge amount of legislation that comes through, and this is constantly evolving, so you need to be aware of it. In Queensland, we have the Sustainable Planning Act, the Sustainable Planning Regulations, and just in those two documents there's over 1,000 pages of legislation. So there's quite a lot of information that you need to be aware of. Now, with this course, there's no study guide, only the prescribed textbook, as I noted, Urban Planning and Real Estate Development. To supplement the textbook readings, the course learning materials will include online lectures such as this one that explore some of the textbook content and also topical issues and how these matters relate to Australian experience. In addition to this, there will be postings and news flashes put up on the website, and of course you're welcome to contact the course coordinator or the course lecturer to discuss any issues. On reading the prescribed text, you'll find that a lot of the content is relevant and in some cases actually parallels the Australian experience and processes. Consequently, I feel that the textbook will provide yourselves as students with a grounding of planning law and processes, and I do encourage all students to read the required chapters. And as I say, this book is either available as a hard copy, which would be a useful resource, or if you don't want to buy a hard copy, we have it available as an e-book for you. Now, I need to note that the comments in relation to Australian planning process will have a Queensland emphasis, as that's where I'm based and that's where I've formerly worked as a building surveyor and a planning consultant. However, we don't want to disadvantage students based in other states or territories, as the assessment questions will ask you to research planning issues in your states or territories. This is intended to allow you to explore and understand the planning controls as they will apply to you in your professional careers, whilst not overloading you with irrelevant material that may be of limited practical use. So we're not going to ask you to look at, if you're based in New South Wales, to look at the Queensland Sustainable Planning Act. You're going to be researching your own legislation. Okay, so topic 1 will focus on Chapter 1 and Chapter 2 of the textbook. Chapter 1 contains an introduction to and context of urban planning, and it explores the following concepts and topics. Sustainable development and how planners can seek to bring about sustainability changes by remodelling the urban form, high-density living, integrated living transport modes, pedestrian access paths, and reducing the primacy of the private vehicle in urban design. And if anyone has an interest in planning, you'll see that these the philosophies and these methods of planning are quite common throughout Australia. You'll see them in Queensland, in Brisbane City Plan, so on and so forth. So there is a relevance to our states and territories. It's also interesting to look at some of the contrasting approaches to planning. These are just two documents that you'll be able to access on the web, and actually there'll be links on the Moodle site to these ones that look at urban development, Consuming Australia main findings looked at greenhouse gas emissions and found that actually inner city and high density populations had a larger greenhouse carbon footprint than outer suburbs, whereas the Griffith University study found a dissimilar finding. It found that taking into account other factors, the opposite was the case. Now, this probably just goes to illustrate that depending on how you look at the statistics and what weighing you put on them, you'll have different outcomes and you'll have different viewpoints formed. At this point in time, it's not really anything to look at. We'll explore this a bit in further depth further into the course, but it was just an illustration that there are often contrasting and conflicting views as to what the best planning outcomes can be. So looking into the statistics presented on page 5 of the textbook, there's some interesting reading. This is in the UK context. 39,000 hectares of land had been turned over to urban development annually in the UK, with an additional 4 million households needing accommodation by 2020. So that's a huge amount of greenfield development and redevelopment and a huge amount of houses. So obviously sustainability gains can be made in material selection and also the built form and environment. So if we go to higher density living with smaller lot sizes, we reduce the reliance on private vehicle use perhaps, and that can have sustainability benefits, not to mention economic benefits as fuel prices increase. Also in this chapter, there's an acronym introduced which is NIMBY, or Not in My Backyard. Now this is a reference that you may or may not have heard, but it's a reference to individuals or community action groups that oppose any development that they perceive as having a negative impact upon their existing amenity. Now oftentimes the arguments will be based supposedly on planning concerns, but more often than not it seems to be to protect the amenity and the property values of their existing areas. And again, when we go into the course further, you'll see some documents and some studies that look at how increasing density and how planning controls can affect housing prices and can create housing bubbles. So there's quite a lot of debate about this subject at the moment, but just at this point in time, just to understand the NIMBY phenomenon and understand that they're out there, and you will see it quite often whenever a development, particularly anything of any major density is proposed, always there are people that seem to come out and oppose it. So reading through the textbook, try to read pages 13 to 90 where the topic of urban regeneration or gentrification is considered in the UK context. Again, there are many parallels between the UK experience and directions, and those proposed for Australia. Also, if you look at the link below, just here, you can see how Helsinki and Finland is addressing similar issues. And for people in Brisbane particularly, I think one area would be Fortitude Valley, where it's been gentrified and turned into high-end residential development. So that's one way that they're looking at, reusing those decayed inner city areas. Also in the textbook, they consider reform proposals such as streamlining the planning process to reduce application times, examination of developer contributions, as charging headworks contributions may lead to the perception of buying planning approvals. This is within a UK context, and introducing new systems to encourage public participation in the planning process. Now, again, in Queensland particularly, we've just been through a process where the former Integrated Planning Act was put out for public comment, public consultation, and was amended to become the Sustainable Planning Act. And one of the reasons given for that was to streamline the planning process. My experience was that it didn't really do that, but you guys might have a different view on that. Additionally, developer contributions are a big factor in any planning debate, and again later on into the course you'll see some papers presented or some studies that argue that developer contributions are another factor that's leading to housing unaffordability and creating a housing bubble. So they're again relevant planning issues. Also in the textbook, there's a history of planning in the UK context. Now, you don't really need to look at this in any great detail, but if you do just read through briefly and have a bit of a skim through, you'll note that many of the same complaints are expressed about the UK system as the Australian system, such as comments of public satisfaction with the planning system does not seem to be particularly high, which could be a bit depressing in that we all seem to have the same problem with planning, and there seems to be a level of dissatisfaction with planning generally. So moving to Chapter 2, we look at the policies that underpin urban planning. Again, it's in a UK context, so there is some limited relevance, but you should look at the following points. Pages 25-26, you provide a brief overview of the challenges facing ongoing development and the utilitarian principles of planning. Now, utilitarian principle is basically whatever the greatest good for the greatest number of people is the right decision to make. That can be contrasted with a human rights approach where nobody should be disadvantaged, and a manifestation of the human rights approach could be looked at as the Disability Access to Building Premises Standard 2010 that was introduced to ensure that all buildings undergoing accessible development were constructed in accordance with AS 1428, the disability standard. So there's two ways to look at this. There's, again, as I say, the utilitarian principle, so the greatest good to the greatest people, which would probably not give much weight to the NIMBY concerns, or the human rights approach that shouldn't disadvantage anyone, and in a planning context that would bring the NIMBY people in and give equal weight to their concerns. 31 to 39 pages, provides a brief overview of the UK reform process. Again, not a lot of relevance, but it's interesting to note that the friction between perceived unacceptable assessment times and community desire for good outcomes exists there as well. So on one hand, there's this friction that exists where on one hand the developers are saying that development times are too long, it's parking our money for too long and it's costing us too much money. Against that, you need to weigh the requirement that the development does satisfy community expectations. So on page 40 of the textbook, there's a diagram that gives a neat overview of the planning application process. I've provided the following diagram that gives a broad description of the Australian planning application process. So if we look at this just briefly, what we see is we usually move preliminary discussions. Following that, the applicant will submit plans and the reports, whatever's required for the planning application to be assessed based on these preliminary discussions and also the requirements of the legislation. Again, for people in Queensland, you will note that the Sustainable Planning Act does prescribe what's required to be included to be made a properly made application. So if this is not provided, it cannot be accepted as an application. Following that, the council will assess the application, and also, depending on the magnitude of the development, there can be external referral agency advice sought. So an example of this could be heritage, it could be environmental considerations. And again, in the Queensland context, the Sustainable Planning Act allows the assessment manager to ask for advice for anything at any time, regardless of whether it's required or not under the statutory process. So following the assessment, where the council can actually ask for referral agency advice, also they can ask for more information from the applicant, so it could be sent back to the applicant with a request for further information. It moves to a report prepared by the planning officer. Now, the report can either be approved, or the planning application can either be approved under delegate authority. So usually you'll see this in minor sort of situations such as a relaxation for a boundary setback or something of that nature. If there's no delegate authority, it goes before the planning committee meeting and a decision is made by the planning committee, which is made up of the elected representatives or councillors. Following this, a decision is made. Now, the decision is either approved with conditions or approved without conditions, but generally it'll always be approved with conditions. Following that, the applicant can appeal the conditions, and depending on whether or not it invited third-party comments, so in Queensland they're called submitters, and it would have been impact accessible, submitters are also allowed to appeal the conditions. If the application is refused again, the applicant can appeal the refusal. So that's just a brief overview of the planning process. So it's probably worth just briefly looking at the Australian hierarchy of legislation within a planning context, because this does have some impact on the ability of planning schemes to control development. So federally, there's not a lot of power and there's not a lot of interest in planning, but under Section 51 of the Commonwealth Constitution, the federal government has power to make laws in relation to external affairs. This wasn't really used in planning context until the Franklin Dams case, which you may or may not remember, but back in the 80s, when in Tasmania they were going to dam the Franklin Dam. Now, the Franklin Dam area was World Heritage listed, and the government at the time, I think it was the Hawke Labor government, used their Section 51 external affairs power to override the Tasmanian government and stop the construction of the dam. So that's where you will see that federal legislation come into play, but it has a limited application. It's where there's a World Heritage listing or something of that nature. Now, the legislation that gives that effect is the Environmental, we'll just go to this slide, is the Environmental Protection and Biodiversity Conservation Act 1999. So that's the federal legislation that gives that effect. Now, where you'll see that legislation being applied is in cases of World Heritage listing, and a couple of examples that are more relevant and current. One was the Traveston Crossing Dam in Queensland, because there were endangered species there. There was a lungfish, there was a turtle in the Mary River and the catchment, and the federal government used the Environmental Protection and Biodiversity Conservation Act to stop the construction of that dam based on that basis. Another one that's just recently occurred was in the Victorian High Country, where the Environmental Act was used to stop cattle grazing in the national parks in the Victorian High Country. So that's how the federal government legislation can be applied. As I say, it has limited application, but it is an important thing to understand. Moving down, the state statutes provide the primary legislative heads of power in relation to planning controls, and these empower local authorities, which incidentally have no standing within the Commonwealth Constitution, to create planning schemes. So this flowchart just really briefly explains the Queensland legislative framework. We have the Sustainable Planning Act, which is given power by the Statutory Instruments Act. It has as subordinate legislation the Sustainable Planning and Regulations. So the Act basically says what needs to be done and why we need to do it, and the regulations tell us how they need to be done. That's sort of the Act, the regulation. That flows down to state planning policies that cover broad areas, and then eventually comes down to local authority planning schemes. And in the case of any ambiguity or dispute, legislation higher up overrides lower legislation as a principle. So if there's a conflict between a local authority planning scheme and the Sustainable Planning Act, the Sustainable Planning Act should prevail to the extent of any inconsistency. So that's a brief understanding of the Queensland legislative framework. Of course, within that we have the Building Act and the building regulations, and there is some overlap between the various acts and legislation, quite a complex little maze of legislation. So moving on to what planning schemes do and what they intend to achieve, they essentially do two things. They seek to identify a type of development, and they seek to identify and prescribe the required level of assessment based on the perceived impacts of that development. So the type of development may be a physical object, so it might be constructing a new building which is an intensification of the site, or it could be a new use. So it could be an existing building, an existing shop, and you need to change the use of that building. So an example of that would be an existing Class 1A dwelling, and somebody wants to change it into office, an accountant office, a Class 5. So that's a change of use of the site. So you either intensify the site or you can change the use of the site. Correspondingly, the level of assessment generally reflects the potential impact of the proposed development. So lower scale developments may be self-assessable, so you don't need any planning consent, you just need to comply with the rules that are within the planning scheme. More contentious developments such as shopping centres or large-scale development may go out to third-party comment and let the community comment on the appropriateness of the development. So if we look at a fairly simple example, building a new house in an existing residential suburb may be self-assessable. So this means, provided that you comply with the prescriptive rules such as siding, building height, building setbacks, etc., there's no planning consent required. That's just self-assessable development. Moving on, for larger scale, possibly controversial developments such as shopping centres, as an example, but there's other examples. It could be factories, it could be anything you think of. Full town planning assessment, including public consultation, may be required. The level of assessment will depend on the zoning of the land, the proposed development, and the requirements of the scheme. So every scheme reflects the community expectations and aspirations, and every scheme will be different in how it assesses the development and what level of assessment it puts on the development. So you need to look at each scheme individually. So if we look at the example of building a new house, BCA Class 1A, just a detached 1A dwelling, in Rockhampton City in Queensland, where the uni is, and using the former Rockhampton City Planning Scheme as an example, what we see is this area here, in the pink, is all zoned residential A. So if you're going to be building a house anywhere within a lot within this pink area, it's zoned residential A. Looking at the planning scheme in the Frenchville residential area, self-assessable development for building a house is against the house code. So provided you're in that area and you're building a house, it's self-assessable against the house code. If it's some other type of development that's not self-assessable, it'll then tell you what the level of assessment is. It could be code assessable or impact or prohibited development, and it'll tell you what codes have to be assessed against. So that concludes this first topic lecture. I hope that you got some basic information out of it and a preliminary understanding of what we hope to achieve with this course, and also some of the planning concepts. Always remember, please keep in touch, have a look at the forum postings, keep on the Moodle site, go in a couple of times a week at the very least, and if you have any questions and comments, either contact the lecturer, the course coordinator, or go onto the forum and leave a posting so we can respond. So thanks for your attention, and we'll see you again next time.